What is particularly notable here is the history of affirmative action jurisprudence. There have been other Supreme Court cases that have considered this exact question, whether schools and universities can consider race in the admission process, and it's basically been a gigantic mess of jurisprudence because the people who were affirming and approving of the use of race were simply affirming the outcome. There was no constitutional dogma or doctrine that enabled them to reach that conclusion. There was certainly nothing in the text of the Constitution that did. They just wildly invented things out of whole cloth in exactly the way that Congress would do. The difference, of course, being that Congress is elected and subject to democratic accountability, and members of the Supreme Court are not, which is why it is important sometimes for members of the Supreme Court to invalidate democratically elected laws, but only when those practices that are democratically sanctioned stay within the boundaries of the Constitution. Once they start legislating in these very detailed ways that have no relationship to the Constitution, that is when you get an illegitimate use of judicial power. And the last time the Supreme Court ruled on this was in Grutter versus Bollinger. It was a majority opinion written by Sandra Day O'Connor, who prided herself on being in the swing vote like Anthony Kennedy did, and therefore so many of her opinions took neither one position or the other, but just found some middle compromise ground, the way some member of the legislature would do negotiating various provisions in a legislation in order to garner a majority in support of it. And what the Grutter opinion said back in 2003, so basically 20 years ago, is the following, quote, "The court is satisfied that the law school," it was the University of Michigan, "adequately considered the available alternatives to using race in the admissions process. The court is also satisfied that in the context of individualized consideration of the possible diversity contributions of each applicant, the law school's race-conscious admissions program does not unduly harm non-minority applicants. Finally, race-conscious admissions policies must be limited in time. The court takes the law school at its word that it would like nothing better than to find a race-neutral admission formula and will terminate its use of racial preferences as soon as practicable. The court expects that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Where did that 25 years come from? She just like pulled it out of her hat. Like, I think maybe 25 years from now, society will be sufficiently race-blind that will no longer need affirmative action. And in 25 years, even though it's constitutional now, it won't be constitutional then. The idea that there's anything in the Constitution that even remotely suggests that that is a proper form of behavior or approach analytically for a Supreme Court justice is preposterous, and yet that has been how these decisions have been handled. Now, today's decision, which is entitled Students for Fair Admissions, Inc., versus the President and Fellows of Harvard Law College, which also included the race-based admission process used by the University of North Carolina, talked about these prior decisions, including the Bakey decision in 1978, which kind of gave approval to the use of race-based admissions by the University of California at Berkeley, although even there, the jurisprudence was even more of a mess. And so this is what the court was dealing with. Just to give you a sense for how unhinged and unrooted all of these rulings have been, approving of these race-based admissions when it comes to the only document they're supposed to be enforcing, which is the Constitution in this case. Quote, "The court first considered whether a university may make race-based admissions decisions in Bakey," that's the 1978 case, "in a deeply splintered decision that produced 6 different opinions. Justice Powell's opinion for himself alone, nobody signed on to that opinion, even though it got interpreted later on as the majority opinion binding the court, would eventually come to, quote, serve as the touchstone for constitutional analysis of race-conscious admissions policies," quoting the Grutter case in 2003, which we just showed you by Sandra Day O'Connor. "After rejecting 3 of the university's 4 justifications as not sufficiently compelling to allow race as a factor, Justice Powell turned to its last interest asserted to be compelling, namely obtaining the educational benefits that flow from a racially diverse student body. Justice Powell found that interest to be a, quote, constitutionally permissible goal for an institution of higher learning, which was entitled as a matter of academic freedom, quote, to make its own judgments as to the selection of its student body. Now remember, this is the same court that is currently deciding whether tiny little bakeries or tiny little internet firms, not gigantic institutions with hundreds of billions of dollars in endowments and massive real estate holdings that affect people's lives in the most fundamental ways, just tiny little small businesses, have the right to refrain from, saying, making a cake that celebrates same-sex marriage because their religious conscience teaches them that it's wrong to do that. Those people don't have, according to this mindset, any kind of rights of conscience, but universities, these public institutions included, can just decide whatever they want to do regardless of what the Constitution says. Even the liberals on the court were compelled to admit that that was not an unlimited, arbitrary, unlimited autonomy, because the Constitution does govern what they could do. Here from the Bakey case, but, quote, a university's freedom was not unlimited. Quote, racial and ethnic distinctions of any sort are inherently suspect, Justice Powell explained. And antipathy toward them was deeply, quote, rooted in our nation's constitutional and demographic history. This is today's court. The second risk is that race would be used not as a plus for, say, minority groups, but as a negative to discriminate against those racial groups that were not the beneficiaries of the race-based preference. A university's use of race, accordingly, could not occur in a manner that, quote, unduly harmed non-minority applicants. To manage these concerns, Grutter, 25 years later, imposed one final limit on race-based admissions programs. At some point, the court held they must end. Recognizing that, quote, enshrining a permanent justification for racial preferences would offend the Constitution's unambiguous guarantee of equal protection, the Grutter Court, that approved the University of Michigan's race-based admissions, expressed its expectations that, quote, in 25 years, the use of racial preferences will no longer be necessary to further the interest approved today. 20 years have passed since Grutter, with no end to race-based college admission in sight, but the court has permitted race-based college admissions only within the confines of narrow restrictions. Such admissions programs must comply with strict scrutiny, may never use race as a stereotype or negative, and must at some point end. The university's admission system fails each of these criteria and must therefore be invalidated under the Equal Protection Clause of the 14th Amendment, what we just showed you. The court today said, by accepting race-based admissions programs in which sub-students may obtain preferences on the basis of race alone, respondents' programs tolerate the very thing that Grutter foresaw, stereotyping. The point of respondents' admissions programs is that there is an inherent benefit in race qua race, in race for race's sake. Respondents admit as much. Harvard admission process rests on the pernicious stereotype that, quote, a black student can usually bring something that a white person cannot offer. The University of North Carolina is much the same. It argues that race in itself, quote, says something about who you are. That's their argument. Race in itself says something about who you are. Today's court said, we have time and again forcefully rejected the notion that government actors may intentionally allocate preferences to those who, quote, may have little in common with one another except for the color of their skin. The entire point of the Equal Protection Clause is that treating someone differently because of their skin color is not like treating them differently because they are from a city or from a suburb, or because they play the violin poorly or well. Those are real differences between people. Unlike race. Quote, one of the principal reasons race is treated as a forbidden classification under the Constitution is that it demeans the dignity and worth of a person to be judged by ancestry instead of by his or her own merit and essential qualities. But when a university admits students, quote, on the basis of race, it engages in the offensive and demeaning assumption that students of a particular race, because of their race, think alike. Or at the very least, alike in the sense of being different from students of other races. In doing so, the university furthers, quote, stereotypes that treat individuals as the product of their race, evaluating their thoughts and efforts, their very worth as citizens, according to a criterion barred to the government by history and the Constitution. Such stereotyping can, quote, cause continued hurt and injury, quoting a Supreme Court case from the past, contrary as it is to the, quote, core purpose of the Equal Protection Clause. Now, again, I just want to note here for a minute, and I'm going to read a little bit more. This is the argument liberals are indignant about. That it is offensive to evaluate an individual based on the assumption that their race tells us things about who they are and what they think and the perspective that they bring. That is something that liberals are offended by now, that they're indignant over. The idea that, of course, we should bring diversity to academic institutions. That is, of course, an institutional value, to have exposure to different ideas. But believing that judging people based on race is the way to get you that diversity is necessarily grounded in a noxious assumption about human beings, which, even if you want to believe it, is one the Constitution fundamentally forbids, namely that it's a person's race that tells us about who they are and what they think. Looking at the world from the perspective of people who are non-white, who want to be able to make their way in this world, who want to exercise their right of critical thinking and not be limited by their race, nothing is more offensive than this perspective that the court finally struck down today, at least mostly. The majority opinion goes on, quote, by 1950, the inevitable truth of the 14th Amendment had begun to reemerge, quote, separate cannot be equal. Now, here they're quoting the landmark ruling in in Brown versus the Board of Education, which overturned Plessy versus Ferguson. We can go back. Plessy versus Ferguson was a court ruling that said separate but equal in school systems, meaning a white school here and a black school here, does not offend the Constitution as long as the schools are equal. And the Brown versus the Board of Education overturned that ruling and said separate but equal is inherently unequal if you're separating people by race, based on the assumption that they cannot intermingle because of who they are. And the court is saying today, we're doing what Brown versus Board of Education did. We're overturning racist precedent. The court said, quote, the culmination of this approach, namely the inevitable truth of the 14th Amendment, that separate cannot be equal, the culmination of this approach finally came in Brown versus the Board of Education. There, the court overturned the separate but equal regime established in Plessy and began on the path of invalidating all de jure racial discrimination by the states and federal government. The conclusion reached by the Brown court was unmistakably clear. The right to a public education, quote, must be made available to all on equal terms. That's the celebrated Brown versus Board of Education. The court reiterated that rule just 1 year later, holding that, quote, full compliance with Brown required schools to admit students, quote, on a racially non-discriminatory basis. In the years that followed, Brown's, quote, fundamental principle that racial discrimination in the public education is unconstitutional reached other areas of life. For example, state and local laws requiring segregation in busing, racial segregation in the enjoyment of public beaches and bathhouses, and anti-miscegenation laws, citing all the Supreme Court precedent that ruled that those forms of racial discrimination were also unconstitutional. These decisions and others like them reflect the core purpose of the Equal Amendment Clause, quote, doing away with all governmentally imposed discrimination based on race. Eliminating racial discrimination means eliminating all of it. Accordingly, said the court has held that the Equal Protection Clause applies, quote, without regard to any differences of race, of color, or nationality. It is, quote, universal in its application. The guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. Any exceptions to the Equal Protection Clause's guarantee must survive a daunting two-step examination known as strict scrutiny, which asks first whether the racial classification is used to, quote, further compelling government interest, and second, whether the government's use of race is, quote, narrowly tailored or necessary to achieve that interest. Acceptance of race-based state action is rare for a reason. Quote, distinctions between citizens based solely because of their ancestry are by their very nature odious to a free people whose institutions are founded upon the doctrine of equality. Now, even today's court recognized that there may be times when you can distinguish citizens based on their race. But because of how offensive it is to the Constitution, one needs to present a compelling interest in order to do it, the highest constitutional standard there is. So you can imagine, for example, a disease that strikes certain races more than others. There are diseases like that. And because of that, one can imagine a government program that spends more resources on people of a certain race in their community than others when combating that disease. There would be a compelling interest narrowly tailored to the racial distinction in question. And the universities tried to argue that they have a compelling interest to discriminate on the basis of race in the admissions process, namely that they want to bring diversity to their student body, and to do so, they have to discriminate on race. I guess the university's arguments are, if we don't know the people, and this is why it's so offensive, if we can't analyze the applicants by race, we're going to end up with a student body that's almost entirely white and Asian, or Indian, or some other emphasis on particular groups. In other words, liberals believe that Black and Latino students, and constantly want to convey this to them, that they cannot succeed on their own. That's the argument that these institutions constantly drum into people's heads in the name of racial egalitarianism. That is another thing that makes it so offensive, to constantly tell non-white kids that no matter how hard they work, you cannot succeed. And so about that, the court said, quote, "It is far from evident how assigning students to these racial categories and making admissions decisions based on them furthers the educational benefits that the universities claim to pursue. For starters, the categories are themselves imprecise in many ways. Some of them are plainly overbroad. By grouping together all Asian students, for example, respondents are apparently uninterested in whether South Asian or East Asian students are adequately represented, as long as there is enough of one to compensate for a lack of the other. Meanwhile, other racial categories such as Hispanic are arbitrary or undefined, and still other categories are under-inclusive. When asked at oral argument, quote, how are applicants from Middle East countries classified, such as Jordan, Iraq, Iran, and Egypt? The University of North Carolina's counsel responded, quote, I do not know the answer to that question. Indeed, the use of these opaque racial categories undermines instead of promotes the university's goals. The university's main response to these criticisms is essentially, quote, trust us. That's always the argument of liberal elite institutions. We know better. We're wise, we're well-intentioned, we're benevolent, and we're compassionate, and therefore you should let us do what we want because we are in search of the good. That's all you need to know. Give us the leeway and we will do good because we're good people and we know best. About that posture, the court said, quote, none of the questions recited above need answering, they say, because universities are, quote, owed deference when using race to benefit some applicants but not others. It is true that our cases have recognized a, quote, tradition of giving a degree of deference to a university's academic decisions. But we have been unmistakably clear that any deference must exist, quote, within constitutionally prescribed limits. And that, quote, deference does not imply abandonment or abdication of judicial review. Universities may define their mission as they see fit. The Constitution defines ours. Courts may not license separating students on the basis of race without an exceedingly persuasive justification that is measurable and concrete enough to permit judicial review. As this court has repeatedly reaffirmed, quote, racial classifications are simply too pernicious to permit any but the most exact connection between justification and classification. The programs at issue here do not satisfy that standard. For the reasons provided above, the Harvard and University of North Carolina admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives warranting the use of race, unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. We have never permitted admissions programs to work in that way, and we will not do so today. At the same time, as all parties agree, nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. Now, let me stop there. Let me read that again, because that's a crucial potential loophole that a lot of people are concerned about when it comes to this court ruling, that all it's really doing is pretending to ban race in the admission process, but by leaving open this loophole that I'm going to read you again, it's actually just making it a little bit more bureaucratically difficult for universities to continue to do what they've been doing. The court said, you can't use race just as race. In other words, here are all the black students, here are all the Asian students, here are the white students, here are the Hispanic students, and we're going to now take deliberately 8 of these, even though they have less metrics and fewer numbers than the people in these groups. You can't do that. But they're saying, but what you can do is that nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. So you can write an essay and you can say, I'm a Latino person, and as a result, I faced a lot of discrimination in my life, or I was inspired by my parents who faced discrimination, and the courts can take that into account, the universities can. And what these universities are saying, as they're about to show you in their defiant statements, and what the dissent told them they should think, is that loophole means they can just continue to use race in their admissions process. They just need to be a little bit more careful about it by pretending that it's not really race they're using, but someone's discussion of race. And when the dissent told these universities, here's an easy way around that, the majority opinion, which was written by Justice Roberts, said the following, quote, despite the dissent's assertion to the contrary, universities may not simply establish through application essays or other means the regime we hold unlawful today. And then it issued this warning to universities, quote, a dissenting opinion is generally not the best source of legal advice on how to comply with the majority opinion. Quote, what cannot be done directly cannot be done indirectly. The Constitution deals with substance, not shadows. And the prohibition, quote, against racial discrimination is leveled at the same thing, at the thing, not the name. A benefit to a student who overcame racial discrimination, for example, must be tied to that student's courage and determination, or a benefit to a student whose heritage or culture motivated him or her to assume a leadership role or attain a particular goal must be tied to that student's unique ability to contribute to the university. In other words, the student must be treated based on his or her experience as an individual, not on the basis of race. Many universities have for too long done just the opposite, and in doing so, they have concluded wrongly that the touchstone of an individual's identity is not challenges bested, skills built, or lessons learned, but the color of their skin. Our constitutional history does not tolerate that choice. Now, the distinction that the court is trying to draw there is, I think, a reasonable one, which is, let's go back to the example of Malia Obama. You really can't imagine anybody in the world who grew up in a more privileged way than Malia Obama. She's definitely a black woman in the United States with a history of racial discrimination. And yet her parents are among the world's richest, most powerful, and most famous people, most privileged people, people who can open doors that almost nobody else can for their children. The idea that a black child of working class parents or poor parents have more in common with Malia Obama than they do with their white or Asian or Latino neighbor in their working class neighborhood or in their poor neighborhood is disgusting and obviously false. And yet that's what this race-based admissions process assumes, is that Malia Obama, and obviously she's a stand-in here for any black person who grows up rich or privileged, of which is true for most black students who get into schools like Harvard based on affirmative action. They're not generally poor people who are bringing a different perspective. They're wealthy kids who grew up with wealthy parents in wealthy neighborhoods. But that is the assumption, is that the way you understand a person is not by their experiences, but by their race. That's what makes it so offensive and racist and unconstitutional. And what the court is trying to say is, of course, you can still consider the experiences of any student for any reason. Someone who's disabled and the things they had to overcome will obviously bring a different perspective than people who never confronted that. So they're just trying to say, just because an experience was based on someone's race doesn't mean you have to exclude it. You just can't judge a person solely based on race. Thanks for watching this clip from System Update. Catch our full shows for free, live weekdays at 7 p.m. Eastern on Rumble, and join our locals community at greenwald.locals.com for all of my written journalism, exclusive after-show Q&As, and more.